Assalamualaikum warahmatullahi wabarakatuh. My name is Farah Nabila binti Bazli.
I am AINUL MUNIRAH binti YUSOFF.
I am FARHANIS binti ARZEMI.
May it please, in the Court of Industrial in Kuala Lumpur on 29 November 2019, the panel of the judge are the Honourable Ms. Cik Nur Afiz, Honourable Syed Nur bin Syed Nazir, number 1 from the list of 21312-04956 2019, No Farah Nabila, Counsel for the Claimant, AINUL MUNIRAH, Counsel for the Company.
I am Farah Nabila, reading for the appellant, referred as one Amran, one Bulat in this matter.
I am AINUL MUNIRAH, appearing for the respondent, referred to Malaysia Airline System.
This hearing is arising out of the dismissal of Wan Amran bin Wan Bulat, referred as the claimant, by Malaysia Airline System, which refers as the company on 14 September 2017. The ministerial referent in this case required the court to hear and determine the claimant complaint of dismissal by the company.
May I respectfully start with the hearing?
Yes, you may.
It was submitted by the company that in view of the above statutory provision, the claimant had begun his employment with the company on 1st September 2015 on fresh terms of employment when the company had officially taken over the business of National Aviation from MAS, which is a separate legal entity and distinct of the company. It was submitted by the company that in view of the above statutory provision, the claimant had begun his employment with the company on 1st September 2015 on fresh terms of employment when the company had officially taken over the business of National Aviation from MAS, which is separate legal entity and distinct of the company. It was further submitted that company had, in its attempt to aid him to achieve his optimal weight, and place him on a weight management program with a period of 18 months during which he was consistently monitored, given ample amount of time and opportunities to meet the same, and had even been provided with an aviation doctor. Despite the initiative of the company to assist the claimant, however, the claimant had failed to achieve his optimal weight. It was undisputed that the company had even arranged for an interview with ADS for the claimant. In this respect, the company submitted that it had no hidden agenda other than to identify an alternative employment for the claimant, which is no way a stop that claimant from filing his representation for unfair dismissal. As such, the company prays that the claimant's claim be dismissed.
May I please respectfully start with preliminary objection?
Yes, you may.
One Amran, one Bulat dispute the basis of the termination in particular clause 6.1.2 of paragraph E under weight management program under grooming and uniform guidelines manual, which the company had relied on, which reads as follows. No repeat of the above processes for the cabin crew who have been on their weight management program and do not meet their weight range again. Cabin crew shall then be referred to Industrial Relations (IR) for recategorization or any other action deemed fit by IR. The claimant contended that a mere excess of weight below 1 kilogram cannot disable him to perform his primary duties effectively. Any suggestion that it can be prejudicial to safety is frivolous where continental airlines such as British Airways, Lufthansa, KLM, or Qantas are known for not applying minimum BMI weight to the cabin crews and have yet to encounter any safety issues, as it was suggested during trial by President of NUFAM, which is National Union of Flight Attendants of Malaysia. It was contended further that the company did not procure any evidence from the regulator, the Civil Aviation Department, prior to issuing any circular that support their contention to that effect.
Did the company aid the cabin crew in achieving their optimum wage?
Yes, the company was well aware of the sensitivity of the nature of the task at hand. Everyone is conscious of their weight at one time or another. Ensuring that one is within one's wage range translates into a great deal of time and energy dedicated to one's appearance and health.
Kindly explain to this honorable court what happened thereafter.
Despite the punishment order, the claimant failed to achieve his optimum weight as per the company manual. As such, the claimant was issued a second show cause letter which once again required the claimant to provide an explanation as to his failure to achieve his optimum weight as per the company's manual. The second show cause letter further set out the numerous ways that the company had attempted to aid the claimant in achieving his optimum weight.
Do you agree that this monthly weight-in was necessary for the company to monitor your weight progress?
Agree.
Do you agree that according to this weight card, your weight limit is 79 kg as your height is in fact 1.7 meter?
Agree.
In cases where an employee is dismissed on the ground of misconduct, it is tried in Malaysian industrial jurisprudence that the test to be adopted in respect of cases involving Section 20 of the Industrial Relations Act 1967 is twofold: whether the claimant had committed the misconduct complained of by the employer, and if the misconduct is proven, whether the employer had just cause and excuse for the dismissal. Based on the facts and circumstances in the present case, in its entirety and the evidence adduced by both parties in the proceeding and upon hearing the testimonies of the witness, the court is of the considered view that the company had successfully proved on the balance of probabilities that the claimant was terminated with just cause or excuse. In any event, the claimant failed to show satisfactory evidence that the termination was tainted with malafide or that the termination was a form of victimization. The court has no hesitation in holding that the company has proved on the balance of probabilities that the termination of the claimant was with just cause or excuse. The claimant case is hereby dismissed.
Thank you, my lady.
Thank you, my lady.